The U.S. Supreme Court sides with Oklahoma in a water rights case. The High Court says a Texas state agency has no right to take water from the Kiamichi River without the consent from Oklahoma. The decision ends a long-running legal battle between the Sooner State and the Lone Star State. Here now with more information on the case and the Supreme Court ruling is Washington Bureau Chief for the Oklahoman, Chris Castile. Chris, how are you today?
I'm just fine, Dave. Thanks.
Let's start with some background before we get into what the interpretation was. How long has the case over the Kiamichi River been an issue?
Well, the lawsuit goes back to 2007. Before that, the Tarrant Regional Water District, which supplies water to a lot of North Texas cities, including Fort Worth, tried to buy water from Oklahoma, but Oklahoma basically has this kind of a structure of laws that is just basically outlaws out-of-state water sales. So the Tarrant Regional Water District was an agency of the state government of Texas, filed a lawsuit in federal court in 2007, lost there, took it to the 10th Circuit Court of Appeals in Denver, a federal appeals court a level below the Supreme Court. They lost there, and took it all the way to the Supreme Court, and they lost there today unanimously.
The court was essentially being asked to interpret a 33-year-old water compact among Oklahoma, Texas, Louisiana, and Arkansas. So let's get into it. What did the court say?
Yeah, that's right, Dave. The Red River Compact among these four states, which was approved by Congress in 1980 to apportion the waters, the tributaries of the Red River. And the question in dispute here about this certain part of the compact was whether whenever there's an excess flow from the Kiamichi River, it apportions the water equally to the four states. But it doesn't say whether Texas can come into Oklahoma and get its share. It's just silent on that. So what the Texas agency claimed was, well, because it's silent, it does give us 25% of that water. We can just go get it. We don't have to have Oklahoma's permission. So what the court said today was, that's not how these compacts generally are. States have a sovereign right to their resources, and if they were going to allow for another state to just come in, and if they were going to allow for a state to come in and take water from within their borders, this would all be spelled out in this compact. It would say where you can do it, what you have to do to get eminent domain, have all kinds of kind of procedures and mechanisms in place. And the court said because that's not in the compact, then you have to assume that Texas cannot do it, because most compacts are written with that kind of language. It says specifically, yes, Texas could come into Oklahoma, and here's how to do it. If the compact's silent on that, they cannot.
Chris Castile joining us today via Skype from Washington. Chris, the Supreme Court has had other water disputes before them and refused to hear those cases. Why'd they take up this case?
Yeah, that's a good question, Dave. You never really know. I mean, they don't really come out and say, here's why we're taking it. In this case, I think it had to do somewhat with the fact that the Justice Department, the Obama administration, the Supreme Court wanted to know, well, what do you think about this? Before we decide to take this case, you tell us what you think about this. And the Justice Department came back and said, well, we agree with Texas that because the compact is silent on this point, that Texas should be able to get some of the water from Oklahoma. And they disagreed with the Texas Water Agency on another key point, but I think that at least played into the Supreme Court's decision to take this case and review it. But there's also a lot of Western states that don't have a lot of water, where these water compacts are really important, where this might have had some kind of influence, how this was interpreted. So I think it was important for the court to take this, not just to decide this one question for Oklahoma and Texas, but also to say this is how we view these compacts. If you're one of these Western states that has one, this is what we're going to say about them, and how it will govern how other states can come in and get water.
A little more definition provided today by the U.S. Supreme Court. And Chris Castile providing some analysis for you. Thank you so much, sir.
Absolutely, Dave. Glad to do it.
All right, and more on this story can be found in the Oklahoman and online at newsok.com.